Victory for cash-strapped consumers as the Gauteng High Court rejects the behind-closed-door deal between Eskom and the National Energy Regulator of South Africa. The 54 billion rand agreement would have seen the already strained consumers subjected to an increase in electricity tariffs of about 9% annually. The court has referred the matter back to Nersa and has ordered that the public be consulted. Lobby organization AfriForum was an interested party in the case. The organization's head of local government is Morne Mostert, and he joins me now for some reaction. Good afternoon, Morne. Thanks very much for your time. Take us a step back, if you will, to how you became or you formed part of the case.
Yes, good evening, and thank you, everybody. I think this started last year when Nersa had public participation processes for the original tariff decision that Nersa made. Now, this decision was made and everybody welcomed it as Nersa gave a lower percentage increase to Eskom. So everybody thought that was the deal that was done. But what happened afterwards was Eskom and Nersa, Eskom brought a review application to the original decision made by Nersa, and then they tried to settle it with, telling no one and inviting no one to take part in this process. But the media uncovered this process, and when AfriForum found out about it, we understood that this cannot be possible, and we started our legal team to get to proceedings to take part in this process. We were obviously joined by the Minerals Council of South Africa as well, and that was the 4 parties that was in front of court as well. So it's very important that if the media didn't discover this problem, it might have just gone through and had an impact of, let's say, about between 20 and 25% increase for regular consumers without anybody even knowing that they took such a decision, and that's why it was so important for AfriForum to take part in this process.
Viva the media! But not only did the court refuse to make the settlement an order of the court, but it was, and I'm using my own word, appalled that such a decision could be made without public participation. Now, you would have thought that a state-owned entity like Eskom and the National Energy Regulator of South Africa would prioritize public consultations.
Yes, I think between these 2 parties, the situation is even worse than how you described. The reason for that is Nersa, the energy regulator, was set in place to ensure the protection of the rights of consumers. So they are actually the body that should advocate and fight for the protection of the consumers, yet they go then and make this deal behind closed doors with Eskom. So it is a problem, but we are happy that the courts understood that the impact of this decision was massive. And the impact of this decision goes down to every South African's pocket. And that's why AfriForum said that with in a general sense, this case was very important as it gives a clear image to public bodies that when there are specific decisions that needs to be taken, there needs to be, and it qualifies as an obligation, that there needs to be some type of public participation process to ensure the process of the decision needs to be legal. Furthermore, it's very important that given the context of electricity, that we don't have a regulator that is working together with the power producer or with Eskom in this instance, and trying to cut all of the public out in these decision-making processes. I think it's furthermore important that given the situation of the problems that municipalities and Eskom have, and with their budgeting problems, it is very important that this information must be aired early enough to ensure that Nersa has enough time to have these public participation processes. As part of the court order, the judge basically said that for this specific determination, NERSA must have an additional public participation process, and that the written submissions must be in before the 21st of January. Now, obviously, AfriForum will take part in this process, and to ensure that that amount doesn't just clearly go through as a thumbs up situation, but to ensure that there is a deliberate process and that this process can be open for any stakeholder to take part in this decision-making matter, as there might be other organizations or other bodies that can have a valued input in making this decision for NERSA.
We are yet to be told how this decision was arrived at by the two parties, but what are your suspicions?
I think the pleadings or the court papers had zero explanation, and that was one of the things that bothered the judge as well during the court proceedings, where the judge continuously asked the parties, but what was the mechanism or the process for these two parties to get to this conclusion? And they were not able to supply the court with this information. And that had a negative effect on their argument. I think it should be noted that NERSA must do their due diligence and must fight for the protection of consumers, which they are not doing at all currently. And we must understand that we must request accountability from NERSA's side as well. If it wasn't for the Minerals Council and for AfriForum making this going on this court case, it would never see the day of light. And I think another thing that is important about this court case is the impact that it should have on the whole of South Africa and the context of decision-making processes within a South African context. We cannot have a regulator or any other public body just making exceptional decisions that have adverse impact on the citizens of South Africa without having a due process, without doing it. I think the promotion of administrative justice, PAJA Act, and the Constitution is clear on the mandate of these state institutions. Because they have state power, they must act lawfully within the bounds of legislation. And we currently are seeing that NERSA is not complying with this. And if we even take other decisions that they made before, and the court took note of late decisions and decisions not worthy of legislative muster being made in the past almost decade. So it shows you that there needs to be an institutional change within NERSA to ensure that they actually start defending the rights of the consumers in South Africa, rather than playing alongside or playing a game with Eskom.
Morne Mostert, let me thank you very much for your time.